Alex here with another video on legal nuts and bolts. This video is going to be titled Can Do versus Should Do in child custody cases especially, and I'm not going to make it a high conflict child custody video because it applies in all types of cases. There are things that you can do, usually more than one way to resolve an issue in court, and then there's the way that you should do it. I have seen over and over again videos, like hearing videos and such, where a person representing themselves has more than one way to do something, and they choose the way that's more obnoxious just because they're so angry and they feel like just because they can. And yes, you can do it. You can even argue that the rules of civil procedure require you to do it. Of course, there's more than one way, and the other way is more reasonable. But no, they choose the more obnoxious way because they're angry and they want to be as in their ex's face as possible. Again, I'm not gonna title this a high conflict child custody case because it could apply anytime you're representing yourself, whether you're fighting a landlord or an employer. Especially when they have lawyers and you don't, they're always going to paint you as a crazy psycho who just wants to get revenge. So don't make their case easier for them by choosing the more obnoxious way. Rather than come up with like a list of examples, I'm just going to give one example because I think it's the simplest and I think it'll get the message across. So in a previous video, I think I titled it Notice of Change of Address. I discussed the difference between I discussed the importance of informing the court as to your address because once a court case starts, people can serve you by mailing stuff to you. So the example is kind of based on that process. I think I mentioned in Nevada it's NRCP 5 or JCRCP 5, depending on whether you're in the district or justice courts, that allows you to serve other papers and pleadings, so not the initial summons and complaint. Everything else besides that can be served in various ways. One of them is you can track someone down and serve them personally, again, if you want. And it could actually be you. This time you don't have to find some other person to do it. And that's where you can kind of see where this is going. The other way is you can mail it to their address, so you can avoid a confrontation altogether. And it's easier and it's less stressful. I've seen multiple examples of people who will personally serve like a motion or whatever, something that they can mail to their ex. They'll personally serve it on their ex. In this one example, a guy like forced his way into his ex's house and gave her the papers. And then when he went to court, they used that against him. And of course, the guy said, well, I had to serve her, so that's how he did it. And the judge really couldn't use it against him, but it did blow up in his face. It turned into like a waste of 20 minutes of discussion and argument and trying to find out the details. And when you're going into court and you want to win your motion, do you really want to waste 20 minutes trying to defend yourself and explain why you were going into a house to give somebody papers and the judge even said this, you could have just mailed it to her and avoided this whole thing. Don't do that because it does make you look bad, and the last thing you need to do is play into the narrative which is going to be played. In every single case that I've done for myself, the narrative was always, I'm vexatious because I don't have a lawyer and everything I'm doing is to waste your money. That was the narrative, so I did everything in my power to not look that way. So I hope that when you're in your court and you're representing, I even saw a person who personally served his ex when she had a lawyer. Like, there's no reason to do that. You're not even allowed to. You're supposed to serve her a lawyer if she has a lawyer. If you don't, then, if she doesn't have a lawyer, then you do have to serve her. But again, you could just mail it. Please do. So once I was able to mail stuff, I loved it because it was a nightmare trying to serve my ex. She tried to hide and play all these games and it took forever. So as soon as I had her sued, I mailed everything. It was just, I was so happy that I didn't have to ever find her again, and I could just do it like that so simply, especially when it got so bad in my termination of parental rights that I had to serve her by publication because I couldn't even find her no matter how hard I tried. So just don't do what that other person did. And if you find yourself in any other situations where you can do things more than one way, choose the way that's less obnoxious. Don't play into the narrative of a crazy, vexatious person because it'll pay off in the long run. It won't pay off in the short run, but over time, the judge will start to notice. Even the lawyer, even my ex's lawyer gave me props at a hearing. And I found that to be astonishing for her to actually say that I was the easiest person she'd ever dealt with. And that was because I gave her a bunch of extensions without forcing her to file motions. I may or may not cover motions to enlarge time, shorten time, and continuances. Thinking about it, if I do, it'll be the next video. If not, I probably will never cover that because it's kind of boring. And I don't know, it might help people to understand what that is. With that, I will go ahead and end this video. See you guys next time.